One family thought they had avoided probate. Their parents had a living trust. The house was supposed to be in it. But when we pulled the title, the property was still in the parents' names. The deed into the trust had never been recorded. That mistake cost them 6 months and several $1,000s in unexpected legal fees. In this video, I'm going to show you exactly how to avoid that and how to handle every step of selling a trust-owned property in Missouri. I'm Terry Peterson. I'm a realtor and investor with St. Louis Family Resources, powered by More Realtors. I hold the Certified Probate Expert and Senior Real Estate Specialist designations. Before real estate, I spent years in the regional management in financial services. That background matters because this work isn't just about listing houses. It's about tax implications, fiduciary responsibility, and protecting families during some of the hardest moments of their lives. I work with trustees, heirs, and families across the St. Louis area every single day. So let's get to it. A quick note, this is not legal or tax advice. Always consult your attorney and CPA. But this will give you a clear framework so you can ask the right questions and avoid costly mistakes. Here's what we're covering today. What legally happens to a revocable trust at death? How trustee authority works? When probate is avoided and when it's not? Missouri fiduciary duties under the Uniform Trust Code. Step up in basis under the Internal Revenue Code, Section 1014. Capital gains considerations. How to structure the sale. Common trustee mistakes to avoid. What happens after closing? Now, Section 1. What happens to a revocable trust at death? When someone creates a revocable living trust in Missouri, they typically serve as their own trustee during their lifetime. While they're alive, they can amend it, revoke it, or change beneficiaries. At death, the trust becomes irrevocable. The terms generally cannot be changed, and the successor trustee named in the document takes over. Under Missouri law, trustees are governed by the Missouri Uniform Trust Code, primarily Chapter 456 of the Revised Statutes of Missouri. One key statute is 456.8-801. It states that a trustee shall administer the trust in good faith in accordance with its terms and purposes and the interests of the beneficiaries. That sentence defines your role. You're not acting as an heir. You're not acting based on emotion. You are acting as a fiduciary. That means your decisions must be reasonable, documented, and in the interest of the beneficiaries. Before I go further, if you are already in this situation right now and you need a clear roadmap, I put together a free trust property sale guide that walks through every step we're covering today. You can request it at the link in the description. No cost, no obligation, just a structured step-by-step guide designed specifically for Missouri trustees and families. The link is in the description. Now let's keep going. Section 2. Does a trust automatically avoid probate? Many people have a trust automatic, or many people believe that a trust automatically avoids probate. That is only true if the assets were properly transferred into the trust during the grantor's lifetime. For real estate, that means a deed must have been recorded, transferring ownership from the individual to the trust. The vesting should read something like this. John Smith, trustee of the John Smith Revocable Trust, dated January 1, 2010. If the property is still titled in the individual's name at death, it may still require probate. This is why verifying title is always step one. Before I list any trust property, I confirm how title is vested, whether any liens exist, and whether there are co-trustees. That prevents surprises after a buyer is already under contract. Here's a case study. The title wasn't in the trust. Let me tell you about a real situation I dealt with. A family came to me after losing both parents. They had a living trust. The children were confident everything was included in it, including the house. When we pulled the title, the property was still in the parents' names. The trust had been created, but the deed into the trust was never recorded. Even though there was a trust, the house still had to go through probate before it could be sold. It delayed the sale by several months. That's why step one is always confirming how the property is vested. The takeaway, a trust doesn't avoid probate unless the property is properly funded into it. Section 3, trustee authority versus beneficiary rights. Only the trustee has authority to act on behalf of the trust. That includes signing listing agreements, sales contracts, and closing documents. Beneficiaries receive proceeds. They do not control the sale. If there are co-trustees, the trust document controls whether they must act jointly or independently. Under the code number 456-7-703, co-trustees generally act by majority decision unless the trust provides otherwise. If siblings disagree, the trustee must act according to the trust terms and fiduciary duty, not based on family pressure. Documentation protects you. A case study, a sibling disagreement. In one situation, two siblings were co-trustees. One wanted to sell the house immediately as is. The other wanted to renovate it extensively. The disagreement stalled everything for months. What resolved it was documentation. We prepared a detailed market analysis showing as-is value, light prep value, and renovated projected value, estimated timelines, and estimated net proceeds. Once everything was in writing, the decision became rational instead of emotional. They chose light preparation, sold quickly, and avoided further conflict. The takeaway, structure reduces family conflict. Data beats opinion. Section 4, step up in basis. This is one of the most important sections in this entire video. Under Internal Revenue Code Section 1014, property acquired from a decedent receives a basis equal to the fair market value on the date of death. This is called the step up in basis. Here's a simple example. Original purchase price in 1995 was $120,000. Value at date of death of 2025 was $420,000. Because of Section 1014, the new tax basis becomes $420,000. If the property sells shortly after death for $425,000, the potential taxable gains is approximately $5,000, not $305,000. That is a significant difference. To protect that basis, trustees should document the fair market value on the date of death. This is typically done through a retrospective appraisal or a professional broker price opinion. Your CPA will rely on that documentation when calculating capital gains. If the property appreciates significantly after death, that post-death appreciation may be taxable. If it declines, there may be a capital loss. Document early, it protects everyone. Here's a case study. Step Up saved over $60,000. A couple purchased a home in the early 1990s for around $150,000. By the time of death, the property was worth approximately $750,000. The children assumed they would owe capital gains on $600,000. But because of step up in basis under the Internal Revenue Code 1014, the new basis became $750,000. They sold the property shortly after for $760,000, and their taxable gain was roughly $10,000, not $610,000. If they had not understood step up, they would have made decisions based on completely wrong assumptions. This is exactly why I spend time on this with every family I work with. The takeaway, step up in basis can dramatically reduce capital gains exposure. Document the date of death value. Section 5, Missouri Fiduciary Duty. Under Code 456.8-802, a trustee must administer the trust solely in the interests of the beneficiaries. This includes avoiding self-dealing. Self-dealing occurs when a trustee uses trust assets for personal benefit without proper authorization. Examples include selling the property to themselves without full disclosure, undervaluing the property to benefit one beneficiary over another. Under Code 456.8-813, trustees must also keep qualified beneficiaries reasonably informed about the administration of the trust. In practical terms, that means provide updates, share offers, document your pricing strategy, keep written records. Transparency reduces disputes. Here's a case study. Trustees in self-dealing risk. I've seen situations where a trustee wanted to purchase the property personally. That's not automatically prohibited, but it must be handled carefully. In one case, the trustee obtained an independent appraisal, disclosed it to the beneficiaries, and obtained written consent. Because everything was transparent and documented, the transaction moved forward without issue. In another situation I observed in the industry, a trustee undervalued the property and purchased it below market. The beneficiaries later challenged the sale. That led to legal fees and family conflict that could have been avoided entirely. The takeaway here, transparency and documentation protect trustees from liability. Section 6, strategies for selling trust real estate. Trustees typically consider three strategies. Strategy 1, sell as is. Advantages, speed. Simplicity, minimal upfront cost. The disadvantage, lower potential sale price. Strategy 2, light preparation. This includes removing contents, cleaning, minor repairs, and landscaping. Advantages, broader buyer pool, stronger offers. Strategy 3, strategic renovation. Advantages, potentially the highest sale price. The risk, cost overruns, delays, and market shifts. The trustee's job is not to maximize price at all costs. The trustee's job is to make a reasonable, documented decision that serves the beneficiaries. I prepare a detailed pricing analysis for each strategy so trustees can make that decision with confidence. Section 7, special situations. What if one beneficiary wants to keep the home? A buyout can be structured at a fair market value. An appraisal is recommended. Funds are distributed according to ownership percentages. What if a property is rented? The lease transfers with the sale unless negotiated otherwise. What if there's a mortgage? The mortgage is paid off at closing from the sale proceeds. What if the property is vacant? Vacant insurance should be obtained immediately. Standard homeowners policies may not cover a vacant home. Here's a case study. The vacant house insurance problem. A trust owned a home, sat vacant for 6 months before being listed. During that time, a pipe burst. The insurance company denied the claim because the property was not properly insured as vacant. Confirm insurance coverage immediately after death. Small oversights can become very expensive. The takeaway, if the property is vacant, get a vacant property policy immediately. Section 8, closing and distribution. At closing, the trustee signs in the fiduciary capacity. Proceeds are wired into the trust bank account. From there, debts and final expenses are paid. Taxes are handled. A final accounting is prepared. Beneficiaries receive distributions per the trust terms. Beneficiaries may sign an acknowledgement of receipt. That documentation protects the trustee from future claims. Now, conclusion. Selling a house held in a trust in Missouri is often simpler than probate, but it's not casual. It requires authority, confirmation, title verification, tax awareness, fiduciary compliance, and strategic decision making. You're not just selling a house, you're administering a trust asset under Missouri law. And the decisions you make as a trustee have real legal and financial consequences. If you're a trustee navigating this right now, I want to help. I've put together a free trust property sale guide that walks through every step of this process, from confirming authority all the way through distribution after closing. You can request it at the link in the description. It's free. There's no obligation. And if you'd like to talk through a specific situation, you can reach me directly at 314-918-5151 or email me at terry@stlouisfamilyresources.com. I work with St. Louis families throughout this process every day. I would be honored to help yours. Thank you for watching.